Awesome. Okay. So hello, everybody. My name is Chibundo Egwatu. I work at HITS, and I am the coordinator of the advocacy department there and at the Sex Worker Advocates Coalition. Um, yeah, today we're going to do a little Know Your Rights with the Washington Lawyers Committee about the rights for folks who work in strip clubs. I'm going to pass it to my colleague, Mackenzie, to also introduce yourself.
Hi, everyone. Thank you so much for attending today. My name is Mackenzie Darling, and I am the law fellow at HIPS, and I also work with the Sex Worker Advocates Coalition, and we've partnered with Washington Lawyers Committee for this webinar, so I will pass it over to Joanna.
Hey everyone, I'm Joanna Wasik, and I am a lawyer at the Washington Lawyers Committee for Civil Rights, and very excited to be talking about workers' rights issues with you all.
Hi everyone, I'm the law fellow at the Washington Lawyers Committee for Civil Rights, and I'm also very excited to be here, and thank you for coming.
Okay. So without further ado, we can get started with our presentation. Sophia, you're on mute.
Thank you. So as Joanna and I mentioned, we both work at the Washington Lawyers Committee, which is a nonprofit organization that aims to create social, legal, economic equity. We do litigation, public policy, work with community organizers. Joanna and I both work on the workers' rights team, but we also do work around housing rights, disability rights, policing, and education. Some of the topics that we're going to be covering today include the difference between what an employee and an independent contractor is and the type of protections that each one has, at-will employment and what that is, discrimination, sexual harassment, your rights around wage and overtime protections, and also leave and safety.
Okay, so the first topic we're going to talk about is employees versus independent contractors. And the reason that we start out with this topic is that a lot of your workplace rights are determined by whether or not you are properly classified as an employee or an independent contractor. For example, wage and hour laws, some anti-discrimination protections might apply if you are one but not the other. So that's where we're going to start. So when deciding whether or not someone is an employee or an independent contractor, courts don't necessarily look at the name. So just because an employer is telling you that you're an independent contractor does not necessarily mean that the law would see it that way, and vice versa. Instead, courts look at a number of factors to see how your work is actually performed and what your relationship with your employer actually looks like on a day-to-day basis. So some of the things that courts might look at is employees tend to be people who have employers that tell them when and where they should work. The employer would be the one to provide the materials that are needed for them to do their jobs. The employer has control over their work and how that work is done, for example, by setting rules and regulations. And that employment relationship also has aspects of permanency. It's not a one-off gig. It is a space that employee is coming back to over and over to keep performing that work on an ongoing basis. In contrast, an independent contractor might look more like someone who sets their own hours, someone who might be booking their own performances, bringing their own materials to do their work. They may also be permitted to work for more than one employer. In many of your all's cases, you might be permitted to work in more than one club and your employer is not requiring exclusivity. And perhaps the worker-employer relationship is sporadic or intermittent. You're kind of here and there, but not necessarily just showing up at one place of business to perform over and over. Now, these are not all the factors that courts consider, and you don't have to have all of the ones in one bucket or another in order to be an employee or an independent contractor. Instead, it's a totality of the circumstances analysis. So which one is a better description of what your work relationship looks like? Now, let's say that you are an employee. What protections does that afford you? The law says that you must be paid the minimum tipped wage, which we'll be talking about later. You must be paid overtime if you work more than 40 hours a week, and you must get 1.5 the minimum wage rate for that. You are entitled to paid sick days under DC law, assuming you're a DC worker. You're entitled to workman's compensation if you're injured on the job. You are protected from retaliation. You are also protected from sexual harassment and discrimination under the federal and local civil rights laws, which we'll talk about later. You have health and safety protections. The club can require exclusivity of its employees. There's also a legal requirement that attaches for the employer to report the full wages of its employees, including the tips that those employees are paid, to whatever state or DC government, as well as the federal government that the employer is governed by. Employees are also paid on a W-2 form. Their wages are subject to tax withholding, and the employer pays the employer's share of payroll taxes when those workers are paid. In contrast, what does it look like to be an independent contractor, and what does that legal space look like? Well, clubs do not necessarily have to pay you the tipped minimum wage or really any particular wage. In turn, they can't really require exclusivity, and you have independent contractors have the right to be working for more than one employer at the same time. You could be charged house fees. In general, you would not have sexual harassment or discrimination protections from civil rights laws. That's different in a few jurisdictions, which again, we'll touch upon later. Because you are not paying into, sort of a lot of these systems, you also don't have entitlement to workers' compensation if you are injured on the job. You do not have entitlement to paid sick days under DC law. Generally, the health and safety protections that we talk about do not apply to you in terms of the employer having that duty for you. And independent contractors are paid on a W-9 form, and that worker must then figure out their own tax reporting duties. Those are not withheld upfront like they are for employees who are paid on W-2s. Okay. Now, we just wanted to talk about this one lawsuit that was brought in DC in 2011, in which the court held that in this specific club, the dancers were employees, not independent contractors. So around 10 years ago, 9 dancers sued their place of work, and they worked at the house in DC. The dancers alleged that they had been paid very little, only $30 to $50 per 10 or 11-hour shifts, which ended up being far less than the minimum wage. And the house was also taking deductions from their paychecks for sick days, late fees, other things. The court looked at various factors in its conclusion that the dancers were employees. The house controlled the manner of the work of the dancers. They had to sign in, they had to sign out for shifts, right? That's showing control of the employer. The dancers had to follow certain rules, and they also worked on a regular schedule that was established by the house. All of that was indicative of them being employees. The house, the employer also controlled all the elements of the business aside from the dancing. So the bartender, the DJ, the cover charge, all of that. And then the dancers who did sue the house had worked there for long periods of time, maybe on and off for 12 years, 7 years, 1.5 years. Those were just some of the tenures of the folks who sued. So overall, the court found that the dancers should have been paid minimum wage. They were employees, so they were entitled to minimum wage. That law was broken. They should have been paid minimum wage, and ordered the house to pay them all of the back pay that they were owed. Okay, so now we're going to move into various sections of legal protections. We just wanted to talk about independent contractors versus employees up front because it is a little different.
Yeah, so this next topic we're going to talk about is called at-will employment, which applies to most employees. And basically what at-will employment is if you don't have a contract, your employment's considered at-will. And this means that you can be fired for any reason, a bad reason, or no reason at all. But you can't be fired for an illegal reason. And one example of an illegal reason is a discriminatory reason, which we're going to talk about next. That involves potentially like race discrimination, gender discrimination. But some other topics that we're not really going to go into include union organizing. So you can't be fired for trying to start a union at your job. You can't be fired if you get injured in the workplace. You can't be fired if you are trying to take approved leave, like sick leave, for example. And you also can't be fired for filing a complaint against your employer for any of the above reasons. So we have a couple of examples that might be more relevant to this type of work. So what if a dancer gets fired for having sex, for example, in the champagne room, even if other dancers who do the same thing aren't fired? Well, this is probably legal, and this goes back to the concept of at-will employment, because as I mentioned before, at-will employment means you can be fired for any reason or no reason at all. So there doesn't necessarily seem to be an illegal reason for termination here. But what if you're a dancer and you get fired for calling out sick? This is probably illegal. So under DC law, employees are entitled to sick leave. So it's illegal to fire an employee for taking leave because they're entitled to that leave. But if a dancer is fired for a non-dancing job because the non-dancing employer finds out that she's also a dancer, or has been in the past, what's the situation around here? This is a legal gray area. There's no clear legal violation here, but the dancer might have arguments for gender discrimination or possibly sex stereotyping, which is a type of illegal discrimination. We recommend that you contact the Washington Lawyers Committee to discuss all the details, because the details might change the response. We have a free workers' rights clinic, which we're going to give the contact for at the end of this presentation, and then I'll talk more about as well. So as I mentioned before, even for at-will employees, you can't be fired for a discriminatory reason because that's illegal. So you have federal discriminatory protections, but you also have state and local. You know, DC is not a state, so that the state and local kind of are a little bit muddy there. But generally, all of the federal protections, the states also have to enforce, but the states can also have additional protections. So federally, it's illegal to discriminate against someone because of their race, skin color, national origin, like where they're born, religion, disability, their age, also sex and gender, but this specifically can also have to do with sexual orientation, gender identity, and sexual harassment, which we're going to talk about sexual harassment a little bit more later in this presentation. And also pregnancy. These are probably protections that you're familiar with when it comes to discrimination. But DC also has all of these other additional protections that you see on the screen. For example, if you're a victim of domestic violence, it's illegal for your employer to discriminate against you or in that situation. Your political affiliation, what party you belong to, it's also an additional protection that DC has. So discrimination protections also depend on where you are. So, and employee versus independent contractor. So in DC and Maryland, the discrimination protections apply to both employees and independent contractors, but in most states, they only apply to employees, and federally, they only apply to employees. But most importantly, they apply during the hiring, firing, and while you're working on the job. So if you are not hired because of your race or because of your gender, these discrimination protections apply. If you were fired because of your national origin or religion, they apply then as well.
Okay, now we're going to talk specifically about sexual harassment. It is a form of gender discrimination, and it has a specific definition in the law. So people tend to use the word harassment to mean any number of things, but legally defined, if you want to bring a claim for example, sexual harassment, it has to be unwelcome conduct because of a protected characteristic that you have. So for example, sexual harassment is unwelcome conduct because of your sex, or you could have racial harassment, religious harassment, etc. Types of sexual harassment that are recognized by the law are, for example, unwelcome sexual advances, requests for sexual favors that are unwelcome by you, physical harassment that is sexual in nature, or offensive remarks about a person's sex or gender in the workplace. If that harassment rises to the level of being very severe and pervasive in the workplace in terms of, multiple incidents and ongoing behavior that hasn't been stopped, it can also rise to the level of what's called a hostile work environment, which is a type of sexual harassment. And we also just wanted to note that harassers can be the same sex or gender as the person who is being harassed. So anyone could be a perpetrator of sexual harassment, regardless of gender, and anyone can be a recipient or a victim of sexual harassment, regardless of gender as well. So who is protected from harassment? Sophia just went over this in discrimination, so it's the same answer. In DC and Maryland, we actually have protections against sexual harassment for both employees and independent contractors. That is not true in the vast majority of states, and it is not true in the federal law. Usually only employees are protected from sexual harassment. But here, if you are experiencing sexual harassment as an independent contractor, you have rights and remedies. Part of sexual harassment, or a claim for sexual harassment, is the legal concept that employers have a duty to protect their employees or workers from sexual harassment. So an employer can be liable for sexual harassment by coworkers if the employer knew or was informed of the harassment. So if you are experiencing sexual harassment at work from a coworker, we encourage you to make your employer aware that that is happening, because the employer's duty to protect you and stop it only arises if they are aware. Now, employers are also liable for harassment by supervisors or managers. They are strictly liable for this. So even if they are, not put on notice by it, liability can attach to them. And employers can also be liable for harassment by non-employees over whom they have control. So for example, customers or clients who are in the club, the employer is deemed to have control over those people because they can kick them out, they can set rules about who can come in, who can come out. And the employer's liability arises if that employer knows and fails to take prompt action against the customers or other independent contractors or vendors who are in the club, and fails to do that to stop further harassment. So again, for those folks, the employer has to be on notice in order to be legally liable. So let's go through some scenarios that may arise in a club scenario and talk about where they would fall legally. So let's say a supervisor or manager asks for a sexual favor in exchange for a benefit. So in exchange for getting more money or special treatment of some sort, or to avoid an adverse action. So for example, asks for a sexual favor and threatens to fire the dancer if she does not comply. That is likely illegal sexual harassment. That is a form of sexual harassment that we call quid pro quo. And it is well recognized by the courts, and that would be unlawful. What if a customer is breaking the club rules and is touching a dancer inappropriately? In that situation, we recommend that the dancer report this to the management of the club to put them on notice of the issue. That will trigger the club's legal duty to take action to make sure it doesn't happen again. Then if the club doesn't do that, they might be liable for that sexual harassment in the future. What if a supervisor or manager is giving preferential treatment to employees with whom they're having a sexual relationship? This one could get complicated because there's a lot of different ways that this could play out in reality. But what we can say is that this is likely sexual discrimination against the workers who are not receiving that preferential treatment. And if the workers who are involved in that sexual relationship feel pressured to do so, and it's not a welcome relationship, it's not consensual, then they may also have claims for quid pro quo sexual harassment. This is definitely a situation in which you want to talk to a lawyer about all the details and the dynamics that are going on in the workplace, because it can be a very complicated situation. Next, let's talk about protections from retaliation for employees. It is illegal for an employer to take an adverse action against an employee because of that employee's protected activity. What do we mean by adverse action? What does it look like that when an employer is taking an adverse action? It means something tangible that the employer is doing against you and it's negative. So they're firing you. That's an adverse action. They're demoting you. They're cutting your hours. They're cutting your pay. Maybe they're taking away some other benefit that's really important in your work. That is likely an adverse action. And it's illegal if they do that because you as a dancer engaged in some type of protected activity. So not everything is protected activity, but some examples are for you made a complaint of discrimination or sexual harassment, or you saw discrimination or sexual harassment happening in the workplace and you took some action to stop it, right? You saw someone else being harassed and you stepped in to make it stop happening. You could not be fired for that. That would be an adverse action because of protected activity. Protected activity also includes using leave that you're entitled to, requesting an accommodation based on your disability or maybe based on your religion, which you have the right to do, or asking coworkers about their wages to uncover potentially unlawful practices. So if you do any of those things and then the employer fires you or docks your pay or anything in response, that is likely unlawful retaliation. So let's just look at one example of how this might play out. What if a dancer complains to a manager about a customer that's being too handsy? And the manager, instead of taking action to protect that worker, turns around and fires that dancer or takes her off the schedule for a few days, docks her pay. That's probably illegal. It looks like that dancer complained to the manager about sexual harassment from that customer, and the manager took an adverse action because of that complaint. So that is probably unlawful. So what can you do to protect yourself if you are experiencing any form of discrimination or harassment on the basis of a protected characteristic or retaliation? Write it all down. Details really, really matter. Later, when you're explaining it to someone, if you want to go through a legal process, if you want to even explore your options of going through a legal process, details matter. So dates, witnesses, anything that can later be used to jog your memory, to put it all together. Consider telling your supervisor and documenting it. And I say consider it because obviously we want you to be safe in the workplace. And if your supervisor is the harasser, it might not be safe to then go make a complaint to that same person, right? However, if it's a customer or someone else, we encourage you to, yes, go talk to management and report it to make that employer on notice. And write it down for yourself. If you make a complaint, make sure you make a record of it too. Keep any photos if that kind of thing is relevant in the situation you're facing. If any documents at all are produced or generated, just keep copies. Don't throw anything out. And then you can call us or you can call another attorney for help. And just one last thing to be aware of in this space is that you have time limits on when you can report incidents of discrimination, sexual harassment, or retaliation. They're around a year. In DC, you have 365 days from the date of the last, incident. For under federal law, it is 300 days, so a bit less than a year. But if you kind of use less than a year as your rough marker in your head for taking action before then, that'll make sure you don't run out of time on anything that you've decided you want to act on.
So we also wanted to talk about your rights around minimum wage and overtime. So tipped employees have to be paid the tipped minimum wage. So the tipped minimum wage varies federally and by state. So the information on there, federally $2.13 and DC $6, but it's will most likely change this upcoming July. And then Maryland $3.63, Virginia $2.13. But at the end of your day, you should be making minimum wage, including the tips. So you'll see on the right-hand column the information on what the minimum wages are. So federally $7.25, DC $16.10. Again, it's going to be subject to change this upcoming July. Maryland, it depends on the amount of employees that are at the place that you work at, and then Virginia $12. But if an employee doesn't make minimum wage, including the tips, the employer has to pay that difference. Whenever you work more than 40 hours in a week, that's considered overtime. So 41st hour, 42nd, 43rd, that's all time subject to overtime pay. And overtime pay means that you must be paid 1.5 times your normal rate. So if you're getting paid $16.10 an hour, that 41st hour, 42nd, 43rd, you should be getting paid that $24.15 that you'll see here below. So we just want to go over some examples related to that. So what if my employer takes the money I earn from lap dances and puts it into a mandatory tip pool? So mandatory tip pools are legal, but the employer must give proper notice to the employees about how that tip pool works and pay out from it by the regular payday. Also, the employers, the supervisors, and the managers, they can't keep any of that money. Only regularly tipped workers can, and a regularly tipped worker is someone who makes about $30 a month in tips. What if your manager asks to give you part of your tips? Again, that's illegal because managers aren't allowed to share tips with their employees. But what if it's a bartender, a DJ, a security guard that are asking for part of your tips? This is another legal gray area. So managers, as I mentioned, can't share your tips, but if the DJ, bartender, security guard are asking, it's likely lawful. This may be an awkward or even coercive situation, but we recommend in a situation like this, you come visit and talk to us because we would need to hear more of the specifics of that situation and the details around that. What if you are quit or are fired? Does your employer still owe you wages for that time worked? Yes. If you're fired, any earned wages must be paid by the next working day after that date of firing. If you quit, your wages must be paid by the next payday or within 7 days of the date of quitting, whichever one comes earlier. What if you're undocumented? Do you still have the right to minimum wage and overtime pay? Yes. If you did the work, your employer must pay the wages. It doesn't matter your documentation status. And what if your employer does not ask you to report the tips? And your employer doesn't report the tips to the government or show them on your pay stub, and you make more than minimum wage. This may be tax fraud. We're not tax attorneys. We can't give you tax advice. You don't want tax advice from us, but we recommend that you attend the upcoming tax session that HIPS and SWAC are doing. And HIPS can give some more information on that at the end of this as well. So what should you do if you're in a wage theft situation? We recommend that you write things down. You want to think about writing down the first and last name of your supervisor, the name of the company or the employer that you're working for. Addresses are really important, just the location where you work, but also where the company is headquartered. The dates and the exact hours that you worked, and when and how much that you did actually get paid. You have 3 years to file a lawsuit or make a complaint with authorities. If you think that your rights are being violated, again, we recommend that you contact Washington Lawyers Committee immediately so that we can help you with those details. We also recommend that you talk to coworkers to see if they are in a similar situation. There's always strength in numbers.
Thanks, Sophia. Moving on from the wage issues, we're going to get into our next topic, which is leave protections that you have in the workplace, and also kind of safety standards and what you can do if you feel that your workplace isn't safe, your employer isn't keeping it safe. So if you are a DC worker and you're an employee, you have the right to take a sick day and be paid during that sick day. And that employer can't take actions against you or treat you differently because you are choosing to use the sick leave that DC law provides you. Now, how much sick leave you earn under DC law depends on how big your employer is. You will always get some, right? If you're in that less than 24 employees number, you still get some, but you get more leave if you're working at a larger employer. And here on the screen, you can see how much leave, how your leave would accrue depending on the size of your employer. In DC, workers also have the right to paid family leave for a few different reasons. One, bonding with a new child, taking care of an ill family member who has a serious health condition, taking care of your own serious health condition, or also prenatal care. And these are the amounts of leave that the DC law provides you with. It's 8 weeks to bond with a new child. DC is one of the few jurisdictions that has paid family leave, and it's still fairly recent here. And just one note, when we say paid, it does not guarantee you your full wage that you are making. At max, there's a calculation for it, and at max, it would be 90% of your wages, or $1,009 per week. So that it would depend on how much you make now. In addition to DC's paid leave, you also, as an employee, have a federal leave, the Family Medical Leave Act. It is a form of unpaid leave and also work protection while you are on leave. So employees have a right to take that unpaid leave for serious medical issues or to care for family members that have serious medical issues. So if you're in a jurisdiction outside of DC, this might be of more interest to you if you're in a jurisdiction that does not have the paid leave. But similarly to the DC law, an employer cannot treat you differently or take actions against you because you're using your right to medical leave. And FMLA leave is typically 12 weeks. Okay. Now, how do you know if you qualify for either that DC paid leave that we were talking about or the federal unpaid leave? To qualify for that federal unpaid leave, you need to have worked at that employer for 12 months. So you need to have already been there for a year, and you need to have worked there 1,250 hours in the 12 months right before you make an FMLA request. And it only applies to employers who have more than 50 employees. Assuming all of that is true, you get up to 12 weeks of unpaid leave every 12 months. Now in DC, you need to have worked for 12 months and 1,000 hours in the preceding 12 months prior to requesting that leave. The employer must have at least 20 employees, so it applies to slightly smaller employers as well, and you get up to 16 weeks of unpaid leave in that 24-month period. Okay. And if you have questions around, how do you calculate what exactly you're entitled to? How does this apply to you, or how does it not? I realize we're throwing a lot of facts at you, so the best thing is to come to our workers' rights clinic and you can ask all of these questions. Again, we'll give you that information at the end of the presentation because it is a lot of different factors to kind of hold in your head and know what exactly would apply in your situation. Employees also are entitled to workplace health and safety protections. Federal law entitles you to a safe workplace, meaning that your employer has a duty to keep your workplace free of health and safety hazards that they know about. So federal law gives you a right to speak up about hazards without fearing retaliation, getting safety and health training in a language you understand, equipment and stages that are safe for you to work on, safety equipment, if that's applicable in your profession, also to report an injury or illness and get copies of those records, and also request an inspection by OSHA, the federal government agency that is in charge of overseeing workplace health and safety protections. If you want to be exercising any of these rights or wish to file a complaint about any violations you see or concerns you have about your workplace, you should do so directly with the federal agency, which is at the bottom of the slide, OSHA. You can do it in person, you can do it via phone, or if you go to their website, which we linked here, you can also do that online. So that is your remedy for those violations. DC also has workplace health and safety protections that are administered by the DC Office of Occupational Safety and Health. If you wish to file a complaint with them, you can also do via phone, or there's a different number if your employer happens to not be cooperating with you. And all of these things on the slide are things that the DC Workplace Health and Safety DC Office of Occupational Safety and Health has the power to do. So again, for when it comes to workplace health and safety violations, we encourage you to please reach out directly to the federal agency or the DC agency in charge of these standards. Okay. One of the last things we wanted to mention, it is not specific to workplaces where dancers may work, but in general, as a worker in DC, you have the protections of the DC Language Access Act, which basically means that you have right to receive services from the DC government in a language other than English. And there are specific, I think 5 specific languages listed in the DC Language Access Act. You have the right to spoken language, so the DC agency has to provide you with interpretation for your language if you're trying to seek services from that DC government agency. They have to give you an interpreter in person or on the phone, and they can't ask you to use a family member or someone else who happens to be in the room as an interpreter. They have to actually call you a certified interpreter if you were at that agency and trying to access their services, or on the phone. This law also gives you a right to written documents, at least vital documents, have to be translated into any language that at least 3% of those people who use the agency speak, which ends up meaning that, for example, instructions for various forms of applications for services have to be in Spanish in DC here for most agencies. Now, there might be languages that are spoken less often that the DC government is not required to translate. Okay. So a scenario on this, what if you need to access DC government services? For example, you're thinking of filing a complaint or, with the DC Occupational Safety Office or with the DC Office of Human Rights or anything like that, but you don't speak English. You can get a free I Speak card from the DC Office of Human Rights, and that you can carry it with you. It'll alert the agency to your need for interpretation and kind of trigger that right for them to get an interpreter for you. What if the DC agency doesn't give you an interpreter after you've told them that you prefer to use a language that's not English? You can file a complaint with the DC Office of Human Rights, which is responsible for making sure that these agencies follow the law. If this is happening to you, we also encourage you to come talk to us. Okay, now let me turn it over to Sophia to wrap us up here to present some of the resources that we've been referring to.
Yeah, so we've mentioned our workers' rights clinic a few times throughout the presentation, and basically our clinic provides free and legal advice on employment matters and brief services. So for example, unpaid wages and overtime, discrimination, sexual harassment, topics that we've covered during this presentation and a little more. Our clinic is conducted over the phone and it's confidential. It happens every Wednesday from 5 to 9 p.m., but also the first and third Friday of the month from 3 to 5 p.m. I put up the phone number and our email to the clinic. Please feel free to write it down, or take, phone screenshot or whatever you need to do. It's a free clinic. Does anybody have any questions? Feel free to put them in the chat. We're looking at it. And then we put up our information for Joanna and also our workers' rights clinic.
I just coming back in to say maybe we could stop the recording before the questions happen in case someone has a sense